now while we're discussing different actors, or better said, different stakeholders in this topic, I would also say that this discussion on substantive issues isn't only limited to these stakeholders that we've now mentioned, but is also is not only isolated to them, but is also a potential for arbitral institutions to bring a meaningful change in this field. And I would ask you, Niamh, as a representative of one, do you find that there are certain issues that could be used as tools, such as cost and duration of proceedings, consistency of awards through maybe scrutiny, that could be used for promotion of sustainability in this treaty-based dispute resolution?
Thanks, Arnelia, and thank you to join everyone in saying thank you to Association ARBITRI for having me here. It's my first time in Sarajevo, and it's been fantastic since I arrived last night. I can't believe it's only 50 minutes away from Vienna, and I don't know why I've never been here before, but you know, I'm going to break that bad trend from now on. And also congratulations on the fantastic panels this morning. So when Arnelia posed this question of the view of the arbitral institutions, my initial instinct, and don't quote me on this, was we've signed the Green Pledge, so we're done. But I think, you know, we probably do have a bigger role to play. And given that we're referring to all of the other panels, because that's what the last panel does, what Philip Boras was saying this morning in the first panel, I thought was really interesting, because, you know, he was focused on this market here in Bosnia, and he kind of highlighted 3 points that, you know, in order for the market to develop in the energy transition, these steps would have to be taken. And I'll just jog your memory in case you weren't listening to him. The first point he made was opportunities in the market, so green hydrogen and you know, potential projects there, and the requisite infrastructure that we need for this energy transition. The second point was implementation of legislation, and the third point he made was the liberalisation of the market. And then he posed the question of, you know, what will the investment framework be in order for, you know, if there are then disputes coming out of this market. And I said to him in the break, I think I have the answer to that question. So, you know, if we think about the energy transition, that's kind of what Philip is saying. It's an opportunity for smaller markets and smaller players to maybe, you know, dabble in some kind of renewable energies or in infrastructure. And of course, we know that the bigger players have the bargaining power to negotiate protection for themselves. But what will the smaller players do, and what do the states do? And like Stephen just said there a moment ago, you know, how do states bring claims against potential polluters? And that brings me to my potential solution, which is the Vienna investment rules. So I don't know if many of you are aware of the fact that the VIAC enacted new investment rules in 2021. So they're very much in their infancy, they're very new, and we're kind of in the process of, you know, bringing them to the market. And the idea, it was a, you know, working group of very smart people who, you know, really kind of tried to look at the market and consider where there is a potential. And I think what they saw was that there are a lot of smaller investment disputes that are kind of fall between the gaps because, you know, they don't have the requisite money or whatever else one needs to go to ICSID or to have a large investment dispute. So the idea of these rules is to create that possibility for those smaller players. And I think if you look at the ICSID, you know, the new ICSID rules, there's a reflection there that there was a need to create a possibility for lower value investments or for smaller investors with a focus on this region. So if I may, I'm just going to talk through, because Arnelia made the, you know, point about cost and duration, and I'm just going to, without boring you with provisions, because I know that that's the worst thing to have to listen to when you're between this and a cocktail. I just want to highlight a couple of the aspects of the rules that kind of try and make it as cost efficient as possible. And one is that there's no jurisdictional requirement, so any of you that have done ICSID cases will be familiar with that. So it's simply up to the parties to decide whether the Vienna investment rules are suitable for the resolution of their dispute. And as a result, that should basically, you know, you should save an awful lot of time and cost on jurisdictional battles. The second point is that the investment rules allow for the dismissal of frivolous claims at an early stage of the proceedings. So a party may apply for early dismissal of a claim, counterclaim or defence if it's manifestly outside of the jurisdiction of the tribunal, manifestly inadmissible or manifestly without legal merit. The third point is that the rules affirm the power of the tribunal to order security of costs. So the test for the security of costs is simply a sufficient degree of probability. So those of you that are familiar with ICSID will know that it's a much higher hurdle to get that through. And we know that, states in particular, it's always been a concern that the security of cost provision is very high. So that's kind of been made a little bit easier by the Vienna investment rules. And then 3 other minor provisions or major provisions, depending on your position, that encourage efficiency and speedy resolution of the dispute is jurisdictional objections must be raised early on, so no later than the first submission on the merits. A dispute under €10 million will be decided by a sole arbitrator, and the tribunal must render its award within 6 months. So that's kind of a summation of, or in a nutshell, the provisions of the investment rules. And I would encourage you to go on our website and have a flick through them and consider whether it is something that would be interesting in your practice. And the second point that Arnela raised is awards. And Galina, you said this. This is the whole interest of an institution is to administer a dispute whereby the parties get an enforceable award at the end of the day. And I was saying this last night that, we also try and go that extra mile for parties when they have their award. Technically, once it's signed and bound and it's fancy red and white paper, we don't really have anything, technically don't have to do anything with it, but obviously we try and go the extra mile for parties. And in the context of the investment discussion, I was thinking, what is the extra mile that an institution could go in the interest of in the public interest, because we know that the issue of consistency, coherence, predictability and correctness of awards is an issue with the interpretation of treaties. And when we're in this, for what feels like, for me, the beginning of this sustainability discussion, I think it's all the more important that treaties are interpreted in a somehow coherent manner. And maybe this is my kind of common law background coming through, but just that we would establish some kind of coherent body of law whereby you can be relatively sure that a treaty will be interpreted in one way or the other. So if we look at the investment rules again, the non-disputing treaty party has the opportunity to make written submissions on the interpretation of the treaty. So I think that already contributes to what I was saying. And then the second point, and Florian mentioned this in the second panel today, because we're just tying it all together essentially. But Florian made the point about the publication of awards being so important for the public interest, and the Vienna investment rules also foresee the publication of anonymized summaries or abstracts of the awards. And also in the public interest details like nationality of the arbitrator, nationality of the parties, date of commencement of the arbitration, whether or not it's ongoing, whether it's been completed, and what instrument is relevant. And of course, the parties have the option of including the UNCITRAL transparency rules. And then the third point is the potentially controversial one, or the one that I would consider going forward. Like I said, the investment rules are in their infancy, so it's a new ground for us. But in order for consistency and coherence to really be solidified in investment decisions, and Arnela and I had talked about this in advance of whether or not scrutiny is a possibility, a useful tool. And at VIAC we don't have the official scrutiny that the ICC do, but we have what I refer to as scrutiny light. And when I started in the role in January, I thought, if we're trying to sell to parties that we're super efficient, and the reason that we don't have a scrutiny is also to facilitate the efficiency, that parties are not sitting around waiting for awards for 6 months. And we have implemented an internal deadline of 3 days. As soon as an award comes in, it needs to be turned around in that short period of time, which is kind of, at the Secretariat shooting ourselves in the foot in some situations. But, we do what we do. But in all seriousness, in the investment, when we look at commercial awards, we do look at the substance, just to make sure that it's consistent and coherent. And I think the obligation, and we make suggestions to the arbitrators or to the tribunal as to whether they might want to consider, consider maybe a legal instrument or a certain aspect that they might not have taken into consideration. And I think in an investment sense, it would be even more necessary to do that we could, advise arbitrators or suggest to arbitrators that they may want to consider an award where a treaty was interpreted in a different way, and if they do want to interpret it in a different way, that they may want to provide the parties with more reasoning. And I think that's something that a tribunal or an institution can maybe potentially contribute to a bit of consistency and predictability there. And then my last point is something that kind of has occurred to me over the period of our discussion today. We have been considering at VIAC to set up a working group to kind of look into all of these ESG type issues, and given that I feel like this is something that will be accompanying us for a long time, or at least until 2050. In an ideal world, then we're all sorted and we don't need to worry anymore. But to really look at maybe what is it that institutions can do, what is it that we as an institution can do. And in the context of that, I was actually thinking maybe it should be elevated to arbitral institutions as a whole. So the IFCAI, the International Federation of Commercial Arbitration Institutions, is always looking for mandates. There's 53 arbitral institutions in that federation. And maybe that's something that the institutions need to look into together, explore potential aspects of ESG and consider how we can do something, all of us together, for the common good, or, in the interest of sustainability. So that's my tuppence.
Thank you.